Hey, this is Joe Bovino from Bovino Law Group, clearing a path to your American dream. Welcome. This video is about the difference between a trademark, a US trademark, a copyright, or a patent. I get this question a lot, and if you're thinking about applying to register your trademark, you got to know what it is, right? You got to be able to distinguish it from other types of intellectual property or intangible assets. And I want to keep it simple. So here goes. Let's talk about trademark first, because I do a lot of that. A trademark is a word, a phrase, a slogan, a design, a symbol, like a logo, or some combination thereof that identifies the source of goods or services from the goods or services of others, okay? So let's, for example, Nike. We all know Nike. Now, Nike has all kinds of trademarks. They have a trademark on the word Nike. They have a trademark on all the stylistic versions of that word. They have a trademark on the swoosh, the famous swoosh symbol. They've got the slogan, "Just do it," right? I believe they also own the trademark to the Michael Jordan, Air Jordan shoe. You've all seen it with the Michael Jordan flying through the air with the ball up high and his legs spread. All these different types of trademarks. Nike's a big company. It's a big brand. It's world famous, and they own a lot of registered trademarks. And think about the value of those. Now, what about a quick note? You may have heard the expression used, service mark. Is that different? Don't worry about it. Most practitioners of trademark law just say trademark for products and services, but you can make a distinction between a trademark and a service mark. More or less, they're the same thing. So don't get caught up in that. Just think about trademark. So that's trademark. What about copyright? How is that different? Best way to think about copyright is think about it relates to the rights of an author, for example, of a book, or the creator of a movie or a television show. It protects literary or song, protects literary, artistic, musical, dramatic, or other intellectual works. It also protects software code, which is a little trickier, but the idea is, I just think of it in terms of authoring this creative stuff, like a book or whatever. You know, you're the author, you have these ideas in your head for a book. I've written a couple, as you may know. And you write it down. You write it down. You express yourself, your ideas, your story, and then you get it out there. You've got copyright rights, intellectual property rights, intangible rights in that work. You can do things to protect these rights, like register your work with the Copyright Office, just like you can register trademarks with the USPTO. But the point is, just think in terms of explaining what it is, it's that you expressed on the paper and then published. You wrote a song, same thing. You came up with a TV show or a treatment for a TV show or a screenplay, these types of things. When you look at a movie, that movie is copyright. It's copyrighted, right? And think about the value of some movies you've seen. What is that worth? Well, the copyright on that is worth, those are worth a lot of money. So copyrights can be very valuable, just as trademarks can be, but they're different. What about patents? Patents are, when you think about patents, just think about inventions, okay? Inventions. Oftentimes, you know, when you have an invention, you have a person who has some engineering skill, or maybe you had an idea and you hired an engineer to create it. And patent lawyers tend to be engineers, right? If they're prosecuting patents with the patent bar, they have to be with the patent office. They have to be a member of the patent bar and engineers. So Nike, for example, you know about the Nike brand. If Nike has a commercial, they have a copyright in the commercial they put out, right? But Nike also invents things, or they have inventors that do it, they're employees, and it becomes an asset of the company. What about some air pump at the bottom of the sneaker, or some fancy thing they did with the sneaker that's unique, some original invention that relates to a sneaker? That would be a subject to a patent, okay? And that's another form of intellectual property law. And you get some exclusive rights to these intangible assets. Okay, so I don't want to get too far into the weeds. I just want to give you a broad brush. Trademark, brand, words, slogans, symbols, logos, think about that stuff. You would register those with the United States Patent and Trademark Office. I do a lot of that work. And by the way, if you have, let's say, you have a word or a phrase or symbol, when you go to trademark it, either you just have what's called a common law trademark, or you registered it. Your trademark relates, if you get it, to what you're doing specifically, your industry, your class or category of goods or services, not every possible use of that word or phrase or slogan, okay? So it's limited in that way, which would make sense, right? Copyright, again, books, movies, that sort of thing, and patents, inventions of all kinds. That's it for today. I want to keep it short. If you have additional questions, you can contact me at bovinolawgroup.com or Joe at Bovino Law Group. And what else? That's about it. Have a great day. Cheers.